This is now for something completely different. Litigation, arbitration, mediation. I really do congratulate Petra and her helpers and others for this, because when I first read the program, I thought this is going to be interesting, but only interesting. In fact, it's turned out to be, for me anyway, really, really interesting and taken us in all sorts of directions. And this is yet a further direction. It's particularly interesting for me because, as I've occasionally spoken from podiums like this, I'm very critical of a number of things, including my own behavior, of course. One, the thing I'm talking about here is criticism of professionals who tend to work in their own silos. So judges are constantly talking to themselves and not necessarily to others outside. I exempt my first speaker, of course, from that criticism. Arbitrators do the same, constantly talking to each other about all kinds of interesting subjects, but not necessarily with others. And mediators, we do the same. We talk to each other about all kinds of things. And it's really interesting to have an audience which is made up of all of those three, and indeed users as well. So I congratulate them. The basis for this conference, of course, is what strategies and tactics do small states follow to secure their survival? How effective are they? How do the Lilliputians on the borders of the giants save themselves from being trampled upon? That's enough from me. We have three excellent speakers. The first, if I can briefly introduce the judge on my far left, the Honourable Mr. Justice Winston Anderson, a PhD from Cambridge. He's a Jamaican national, barrister Lincoln's Inn, also called, of course, to the bar of Barbados and Jamaica, General Counsel, originally to the Caribbean Community Secretariat, a Professor of International Law at the University of the West Indies in 2006. He was elevated to the bench of the Caribbean Court of Justice in 2010 and is a globally recognized scholar on private international law. He's currently a member of the Advisory Council to the UN Environment Programme. Judge, if you could speak to us, I'd be very grateful.
Thank you, Chair, and thank you to the organizers for your gracious and generous invitation. I will be speaking to you this afternoon about the contribution of the Caribbean Court of Justice to international litigation. And yesterday I listened with some envy to a presentation which spoke about the promise and potential of the Caribbean Court of Justice. Envy because not long ago I was an academic and I could speak in those terms. But being on the bench, I'm a bit more restricted. So, for the most part, I'm going to let the court speak through its judgments, the judgments it has given thus far. So, yesterday we heard, for example, that the court has established by agreement 14th of February 2001, happy Valentine's present for the Caribbean, of course. It entered into force, the agreement, in July 2002, and it was inaugurated and became operational on the 16th of April 2005. The court is, I would say, a unique judicial institution. It is, first of all, an international organization with legal personalities. It enters into agreements with states, other organizations. It has a Judicial and Legal Services Commission, which is responsible for the appointment of judges to the bench. Judges are drawn from all over the world, the civil law world and the common law world. If you wish to be a judge, you simply apply. There's a weeding out process, of course, shortlisted interviews, and then you're appointed by the RJLAC. The RJLAC is a non-political body. There are no political appointees on the commission. And the court is financed by CCJ Trust Fund capitalized by contributing members, $100 million, and the interest from that fund is used to finance the operating expenses of the court. The court has dual jurisdictions. It has an appellate jurisdiction in which we intend to replace the Judicial Committee of the Privy Council, and also an original jurisdiction in which the court adjudicates on the revised treaty and the regional integration movement. And finally, there are different modes of dispute settlement in the revised treaty. There's, of course, judicial modes. Both the appellate and the original jurisdiction are judicial modes. But the revised treaty also encourages ADR, alternative dispute resolution, and I hope to get to that right at the end of the presentation. I think the most important contribution by the CCJ to international litigation is this concept of the rule of law. And first of all, the revised treaty in its preamble speaks to the original jurisdiction, or the OJ, as being essential for the successful operation of the CSME. And then the court itself, in an early case in 2009, said that by signing and ratifying the revised treaty and thereby conferring on this court ipso facto a compulsory and exclusive jurisdiction to hear and determine disputes concerning the interpretation and application of the revised treaty, member states transformed the erstwhile voluntary arrangements in CARICOM into a rules-based system, thus creating and accepting a regional system under the rule of law. So it's very, very critical then that the court has noticed that we have moved from a voluntary system which obtained in the past to one which is now based on the rule of law. And I dare say that is the golden thread which runs through most, if not all, of the judgments pronounced by the court. And that concept of rule of law has led to some very interesting developments, and I'll mention just two. One development is the idea of stare decisis, the idea that the judgments given by the court constitutes binding law for all member states in the Caribbean, whether in fact they are participants in the proceedings or not. Now, that is traced to a very interesting article in the revised treaty, Article 221, where in the topic there, the title, you see the judgment of the court to constitute stare decisis. So that seems pretty clear, but the text of the article is a bit more ambiguous, because the text says judgments of the court constitutes binding precedents for the parties in proceedings. And that's a classical rule, of course, of international law, that decisions of tribunals, international tribunals, are binding only on the parties to those proceedings. But from as early as 2009, the court signaled that it intended its judgments to be binding on all member states, participants or not, to proceedings. And the court made the point very, very forcibly in the later case of Shanique Myrie in 2013. And the court said that the jurisdiction and authority of this court is to be sharply contrasted with, for example, that of the International Court of Justice. The jurisdiction of the ICJ is unlike this court's original jurisdiction, not compulsory, but based on the consent of parties. It would not be appropriate to compare favorably Article 221 of the revised treaty with Article 59 of the ICJ statute, which specifically indicates decisions of the ICJ have no binding force except amongst the parties. The court's interpretation, it said, of Article 221 as embracing a system of binding precedent for all member states of the community is supported by those who worked closely with the drafting of the revised treaty. So that's a very, very important development. Whether you're a party or not to proceedings, you are bound by decisions of the court. A second principle which flows from this idea of the rule of law is that of judicial review. And the court has said very, very clearly that this notion of the rule of law compels the court to the conclusion that it can engage in judicial review of the actions of the community. And not just the community, but the actions of member states as well. Okay, you have the quotation there on the screen. A very, very important development, because there's nothing in the treaty itself which speaks about judicial review, but the court basing itself on the concept of the rule of law, and also on a single article, Article 187, which speaks of the range of disputes possible before the court as including allegations that the community acted ultra vires. Those provisions, it said, were sufficient to form the platform on which it could exercise judicial review. And not just in relation to the community, but also in relation to the acts of member states. But it went further, because Some years later, 3 years later, in another case, you can't see because it's lower down on the screen, Trinidad Cement and the Competition Commission, 2012, the court said that its power of judicial review went beyond states, went beyond the community, and included any act of an institution that was established by treaty in the Caribbean. No conduct of any institution established by the treaty in the Caribbean could escape judicial scrutiny. Related to that notion of judicial review is the point the court made, again in an early case, that the court can engage in judicial review at the instance of individuals, so that private persons who bring actions before the court can in fact be the basis in which the court conducts its judicial review. Okay, so the rule of law is, as I said, very central, and it permeates the entirety, I think, of the jurisprudence of the court. But a second contribution that the court has made, I think, is the clarification of the rights of individuals. Now, I think it's useful to start with Article 222, because that is the article which describes the circumstances in which individuals have standing to appear before the court. The court, of course, normally, or should normally, hear disputes between member states of the community and others, but there is a particular provision, 222, which allows for individuals to bring actions. And one of the first point concerned the nationality requirement, because Article 222 speaks about actions being brought by persons, natural or juridical, of a contracting party. And that is to be related to another article in the Convention, Article 32, which specifies certain conditions before a company will be regarded as a national of a CARICOM state. A certain percentage of the shares must be held by CARICOM nationals, etc. So the question then was whether a company had to be a national of a CARICOM state in the narrow sense of Article 32. Note Article 32 specifically said that it applied for purposes of Chapter 3. So a case before the court said no, juridical persons, 222, need not be a national in the narrow sense of Article 32. What was required was that the company be incorporated or registered in a CARICOM state. Note, however, that there are differing rights for persons. If the company is not a national in the strict sense of Article 32, then it is not entitled to what are called the core rights in Chapter 3. The core rights are the 4 freedoms: movement, capital, establishment of business, provision of services. Those rights are restricted to nationals of CARICOM. But all persons of contracting states enjoy other rights, okay? And one of those other rights has to do with the movement of goods. Movement of goods is dealt with in Chapter 5 of the revised treaty. So that, for example, somebody mentioned yesterday about the custom duty, the common external tariff, that's dealt with in Chapter 5, and all persons have the benefit of the CET. And then, interestingly enough, the court talks about other ancillary rights. And the court basically said that you can identify specific rights in the treaty, for freedoms, for example, but there's a general principle that wherever the treaty imposes obligations on states, they are correlative rights which are enjoyed by persons. So whenever you find any kind of obligation imposed on states, then persons have collateral or correlative rights. Some rights have been found to be breached by member states. Failure to impose the common external tariff, 2 cases there. Failure to permit hassle-free travel. That was found in a recent case from Jamaica, Shanique Mary against Barbados. What was fascinating about this case is that the right to hassle-free travel wasn't actually found in the revised treaty, but found in a conference decision taken under the revised treaty. And the court held that that conference decision, in effect, had a similar status to provisions in the revised treaty. Barbados had breached that provision. And then another right found to be breached, the right to non-discrimination. In one case, a Surinamese company had paid a discriminatory tax, environmental tax. Tax was charged on imports from Suriname, but not charged on like products in Guyana. It was held that that constituted a breach of the revised treaty. And the final point about Article 222 has to do with the standard that must be met before persons can, in fact, bring an action before the court. And essentially, the court has said that all that is required is that an arguable case be established. Now, if you look at the conditions which must be satisfied, one of the conditions, for example, suggests that the person must prove that he has been prejudiced. And that would suggest that, you would have to demonstrate prejudice that has occurred in the past. The court has said, well, that doesn't really mean what it says literally. It means that you must establish an arguable case that you have been prejudiced. Said that in 2009, and then more recently in the Tomlinson case. In Tomlinson, the court said that without making a finding one way or another as to the matter of Tomlinson having been prejudiced, and given all the circumstances, and in particular the relatively low threshold that has to be met in establishing arguability at this stage, the court grants Tomlinson special leave to commence proceedings against Belize and Trinidad and Tobago. So the standard that must be met is a relatively low threshold of having an arguable case. Another contribution made by the court is in the field of remedies which are available for breach. Now, in this regard, there's very little to guide us in the revised treaty. There are no provisions really on the issue of remedies in the revised treaty. But in a number of cases, we have issued declarations that member states have breached their treaty obligations by not observing the rule of pacta sunt servanda. That is to say, you must comply with your treaty obligations in good faith. So we have issued declarations to that effect. We have also issued coercive orders. We have ordered governments to do things that come into compliance with their treaty commitments within a particular time. So in the case of Trinidad Cement Limited against Guyana, Guyana was given 28 days, relatively short period of time, to reimpose the CET on cement from Venezuela. And then damages. For a long time, the court did not award damages. The court said in 2009 that there's a fairly high standard to be met in the award of damages, so that the claimant had to prove that there was a serious breach of his treaty rights, the breach had resulted in substantial loss, and that there was a link between the loss and the breach. So the court is a little bit concerned about the award of damages, perhaps. But in fact, in Mary against Barbados, the court did in fact award damages, both pecuniary damages and, interestingly, non-pecuniary damages, damages for the inconvenience which had been suffered by the young lady in not enjoying her freedom of movement. And also reimbursements. The court has in fact allowed for reimbursement. In the case I mentioned earlier about the environmental tax, the claimant company had difficulty proving that it had suffered loss. The argument was that the tax which it had paid had been passed on to the consumers via the prices, and therefore it was hard for them to prove the loss. But the court said, well, look, we're not really going to award damages here. What we're awarding is reimbursement of the taxes that you have paid. And therefore it sidestepped the issue of whether the conditions for damages had been met. And interestingly enough, the court devised a monitoring mechanism to make sure that its judgment was complied with. So the parties have to report periodically to the court to advise about how the award is being implemented. And happily, the award has now been implemented. I think there was a recent compromise between Guyana and the Suriname company. Implementation by member states, very briefly, that is also linked to the idea of the rule of law. The court has said that there's a general undertaking in Article 9 that parties must, in fact, comply with their treaty obligations. Now, there is the point, of course, that in international law, the fact that legislation is not consistent necessarily with your treaty obligation doesn't necessarily mean a breach of your international obligation. There are lots of cases that say that it really depends on how and whether the legislation is implemented in fact. So the court has said that the mere fact that there's legislation on the books which appear to be in conflict with the RTC is not sufficient to establish that there is a breach of the treaty requirement. So for example, in the Mary case, it said that in lieu of amending or repealing legislation, Barbados could rely upon its administrative acts which are then consistent with the treaty. Of course, Tomlinson has challenged this, and Tomlinson has said that the mere fact of having legislation on the books which are incompatible with the revised treaty constitutes a breach of his treaty rights. And that is the case which is due out very shortly, and one of my colleagues I know is very interested in that case. Finally, I would say that the court has encouraged, particularly through its rules, greater participation and access in its processes. So, for example, where there is an original application, where an individual has started proceedings before the court, the registrar notifies all member states that there is this proceeding pending. Similarly with referrals. And the idea is that it's linked to the rule of law, because if all member states are going to be bound by the decision, then they should have an opportunity to participate in the proceedings before the court. And the court has also allowed greater access to the general public. For example, we have used electronic filings, file documents, proceedings electronically before the court. We have provided in the rules for amicus briefs and also for providing evidence by video link. And the evidence in the Tomlinson case was provided by video link. Mr. Tomlinson was in Jamaica, and we heard the case in Trinidad. Brief word about the appellate jurisdiction, and now we're looking at private international litigation. And to my disappointment, there is no case really on private international law. As you may have heard, I have a particular interest in private international law, but there's been no case on forum nonconvenience, no case on choice of law, no case on the recognition of foreign judgments. But note that there is a particular provision in the RTC, Article 223, which encourages international commercial arbitration. And that article provides that member states are obliged to facilitate the use of arbitration, and in this regard, they must adopt appropriate legislation. And it goes on to say that the requirement to adopt appropriate legislation is implemented by using the New York Convention, by implementing the New York Convention. And there was a very, very strong statement of support by the CCJ for international commercial arbitration based on party autonomy, based on the efficiency of the process. I noticed some people who spoke yesterday promoted themselves, promoted their books and so on. I don't promote myself, but I must say you should look at the judge who gave these wonderful statements about support for commercial international arbitration. Now, one of the things that we have spoken about is the jurisdiction of the arbitral tribunals. And in one case, 2013, the court was confronted with an injunction issued by the Belize Court of Appeal, which restrained international arbitration proceedings. These proceedings should have taken place here in London. Court of Appeal said, no, you are injuncted from going forward with these proceedings. And the Court of Appeal reasoned that the right to arbitration was dependent on the prior completion of proceedings in domestic courts. Caribbean Court of Justice discharged that injunction. Court said that we would exercise heightened vigilance when asked to restrain international arbitration, and we would only allow an injunction where the arbitral proceedings were vexatious or oppressive. In terms of the enforcement of arbitral awards, there's a case there, Moranco, in which, of course, we allowed for the enforcement of an award. But note finally the case of BCB Holdings Limited and Belize Bank against AG 2013. In that case, we reiterated that enforcement of arbitral awards would only be refused in the rarest of cases. We have respect for international arbitral bodies, their judgments, their opinions, and therefore would normally enforce those awards. But in this case, the London award was based on a deed of settlement that created a unique tax regime in Belize. And that tax regime was not authorized by Parliament, and it said that it could not be altered by Parliament. Now, under the Constitution of Belize, only Parliament has the power to regulate taxes and taxation. And therefore, we felt that this settlement deed was illegal and unconstitutional, and therefore the enforcement of the award would be contrary to public policy, and therefore we refused to enforce that award. Enter the US Supreme Court. Because those who were unhappy with our decision went to the United States Court and sought to have the award enforced. And there were conflicting decisions in the US courts as to whether to allow enforcement of that award. And the US Supreme Court has agreed to hear this case and has agreed to opine on two critical issues. First of all, the vitality of the forum non-convenience doctrine. Is this, the United States Court, a proper forum to hear this enforcement proceeding? And secondly, the United States Court is to look at the proper balancing of the public policy interests. Now, of course, needless to say, the opinion of the US Supreme Court is awaited with great interest. Thank you very much.
Thank you very much indeed, Judge. Description of a court of very wide jurisdiction, possibly a model for Pacific states because of the coverage of a number of states and its very broad jurisdiction. Thank you very much indeed, sir.